Hi there.
Hello. I didn't see who that was. Was that?
That's me, Pua.
Oh, hi, Pooh. I got your message. I'm not sure why the calendar is, but
Yeah, it's kind of messed for me at least. It's messed up.
oh, you should do it. Your note taker does, because it seems to know.
Yeah, apparently.
Well, let's talk about that sometime because you may need
Yeah,
to. We've created recurring meeting. So I don't know, right? Obviously, your note
yeah.
taker can read your calendar and knows.
I don't know what's
I
going
don't
on.
know. I was there with a bunch of note takers the other day.
I mean, I logged on one day at 12:30 and it said the meeting was at 9:30 and it was just I don't know.
You get an email from me every week that has a list of the
You're
upcoming
right.
sessions. It's
And
that.
that's what I do all of my next week scheduling off of. So I'll work
Oh,
on it.
show
My
us
computer
sometime.
hasn't been working. My computer hasn't been working right recently, so
I don't know. I don't know. Some people made it. Well, certainly note takers were able to find it. You know.
Good afternoon, Michael.
Good
Khalid.
afternoon, Khalid. How you doing?
Doing good, thank you.
Hi, Angelo.
Hello, Mike.
Long time no see.
Hello, Michael. How you doing?
Good. Who is that?
AP.
Oh, JP. I have to look and see who's my
That's okay.
movie. Um, okay. It's time, I guess. I'm putting a link in the chat, and that's not right. And if somebody could just verify that in fact opens up, and maybe Angela and others could copy it so that when tardy ones show up and say, "Where's the handout? I have the handout. I want the handout."
Michael,
It opens up.
it opens up. Thank you.
Then you could all be a hero and give them a copy of the handout. Right? All right. So, and I assume you can see this my screen.
That's correct.
Good.
Yes.
Just seeing if you're out there. I'm not always sure. So, what we're talking about today are new laws that are in effect or going into effect in 2025 that real estate agents should know about. To start with, I've made, well, with the help of others, let's just say, a deep dive. This is a podcast audio uh, generated through an AI program of that Google has called Notebook LM. For those of you that like to listen more than to read, you might want to check it out. There's a table of contents. As you can see, there are hardly any new laws that are going into effect this year, like hardly any, right? Just, well, 23. And in fact, there are others that I didn't get to, right? Because I could have going on. Hi there, I'm a meeting agent. All right. So we're going to talk about here. Let me just do this. I thought I'd already done that, but I'm going to do it this way. All right. So within each of these different categories, there's a lot more details that I don't really have time to go through. But just so that you realize what's going on and what's possible, so if it comes up, you'll at least know to research it. There is a free the ADU law, right? Not only is it not putting the illegal units in jail, it's offering them amnesty. Doesn't that sound awful? And so what they recognized in California is that there are a lot of people that have unpermitted ADUs. And if you're wondering what an ADU is, it's an accessory dwelling unit. And a JADU is one that's, I think, joining. It's the difference between one that's separate versus one that's not separate. And if they were built before January 1st, 2020, even if they don't have the proper permits, they're probably not going to make them tear it down. And the local governments, as a result of AB 2533, have to offer a no penalty pathway to legalize it. Now, in the past, if I get this question a lot from real estate agents that I work with, which is there are unpermitted additions. Oh my God, what are we going to do? We can't sell the house. We can't buy the house. None of that's true. So if you have unpermitted additions, what's the worst that could possibly happen? And the answer is they'd make you remove it. If it's built to code and or could easily be brought to code, or even not easily, if it can be brought to code and it's built to code, they'll make you bring it to code and then permit it and then make you pay the fee plus a hefty fine, which is why people don't volunteer, hey, come and check out my ADU and tell me if it's built to code. So, it says you can have a third-party inspection, which means that you could have somebody come out and look at it and tell you if it's up to code or not. So if you have a client with an ADU, either selling or buying in the transaction, and it's not permitted and was built before 2020, there's a path around it. There's good news. Number 2 is the balcony and elevated element inspections. Which is there's partial good news with the balcony disclosure and the balcony rules. The good news is that most apartments there's been a moratorium on a lot of it. However, what's relative to us is condominiums. So what they did for apartment buildings, let's say you have 4 units or 40 units or something like that, and it's an apartment, then they've pushed the wood-based balcony inspection rule to January of next year. However, the condominium still applies now. All right. And what the issue is that if you have a balcony that is supported by wood, which is sometimes hard to tell. If it's supported by wood, it needs to be inspected by somebody licensed to conduct those inspections. So for most of the units, it's been delayed to January 1st, 2026, but not condominiums. And by the way, this could be sometimes challenging, but the word condominium does not necessarily mean what you see on the multiple listing service, because a condominium is really more of a form of ownership, as opposed to a PUD, which stands for planned unit development, which is what would be a townhouse. So if the form of ownership is condominium, which means you have a separate interest in your own space, plus a common interest in common areas, then the law applies now. Now, if what that means is that if you're selling a condominium or buying, your client is buying a condominium and you're looking around and you see wood balconies, well, then you'll probably need to get this inspection. Does the wood balcony have to be connected to the unit that you are buying or selling? And the answer is no. No, it just has to be a building that's got these wood balconies. right? And then they have to be inspected by somebody licensed. Now, this would be so easy if people would cooperate. And I don't really mean people as people. I'm talking about homeowner associations. Because when you get down to it, who really is responsible to have the balconies inspected by the engineer? It's the homeowner association. Well, what if they don't do it? Has anyone out there ever dealt with a homeowner association that just ignored rules and just wouldn't do things? You know, I have. And if you haven't, it means you haven't dealt with enough homeowner associations yet. So they're the ones that are supposed to do it. If they don't do it, then the seller or the buyer could have it done, but you would preferably want the homeowner association to have conducted the inspection and have documentation that they did so and that the balconies passed. By the way, if there's any one of these you want, you shout. All right, I'm not necessarily watching the chat. I have enough time just talking and, you know, sitting straight at the same time. Buyer representation agreement requirements, AB 2992, went into effect January 1st of 2025. Many of you, hopefully most of you, have heard about the National Association of Realtors / MLS legal settlement that went into effect August of last year. By the way, it's being appealed. And you might be thinking, hey, you know, maybe on the appeal, we're going to win. And they're going to throw the settlement off and we can all go back to the good old days when the MLS said how much I'd be getting if my buyer bought a house. Well, first of all, it is very unlikely that that appeal, this is according to the California Association of Realtors Legals Department, it is very unlikely that that appeal is going to be successful. And even if it were, it doesn't change anything. And the reason it doesn't change anything is that separate from the NAR court settlement, California passed a law that requires buyer representation agreements. Now, some of the differences are the National Association of Realtors court settlement, which affects MLSs as well as if you're a member. That settlement only applied to 1 to 4 units residential properties. It did not include commercial properties, apartment buildings, multifamily, you know, 5 or more, land. It didn't include all that. The new law does. The new law does. So it doesn't matter what kind of property it is, doesn't matter, commercial, 50 units, doesn't matter. The buyer representation rule is in effect. The other difference is that the NAR settlement, and this actually isn't much of a difference, but the NAR settlement said that the agent would have a signed buyer representation agreement before they showed property. I think it said touring the property, which meant either in person or, you know, using a video walkthrough. Now, the California law says that as you should have the buyer representation agreement signed with the buyer as soon as practicable, but no later than when the offer is being written, when the offer is signed. Now, many real estate agents are thinking, oh, that means I don't have to do it until, like, let's say it's commercial property, not covered by the NAR settlement. I don't really have to do the buyer representation agreement until we're writing an offer. Not so fast. And the reason I'm saying that is the California Department of Real Estate has interpreted the phrase as soon as practicable. And they're apparently in the process of writing a commissioner's regulation on this subject, but their definition is before you show the property. Because the Department of Real Estate is thinking that if you're going to show the property, then you're going to meet that and you could get them to sign the form, right? So even though the law doesn't say when you're touring the property, it's going to mean when you're touring the property, just because of the way as soon as practicable. By the way, technically, if a buyer was asking you for information about a property, what do you think it's worth? Could you give me the disclosures? Can you run comps for me? All of that would require a buyer representation agreement. What about open houses? So can you, as a real estate agent, show the property to a buyer at an open house? They walk in, they say, hey, can you give us a little tour? And you explain stuff to them about the property. What's the school? What's the elementary school? You know, that sort of thing. Can you do that without a buyer representation agreement? Or would you need a buyer representation agreement if you were giving them a thorough tour of the property and answering questions about the property? Now, I hope everybody understands what my question was. Now, the answer is yes, if you're the listing agent. What does that mean to be the listing agent? Now, you might think, well, that's a dumb question. Everybody knows what it means to be the listing agent. The listing agent is the brokerage, not the person who signed the listing. So, for example, if you're doing, let's say you're at EXP, and now EXP has 4 divisions, but the Department of Real Estate, I believe, considers us all one brokerage, right? Because we didn't want to have 4 divisions. They made us have 4 divisions because we're so big. But in their eyes, we really are just one brokerage. It's all the same people. They don't, they're not tripping about that. But let's say you're an EXP agent and you're doing an open house for another EXP agent, then you have the power, the ability, the authority to represent the seller regarding that property because the listing belongs to the broker and you belong to the broker. However, but you're doing that as an agent of the seller, not as an agent of the buyer. All right. Does everybody understand that? But if for some reason you were doing an open house and it wasn't an EXP listing, or not our EXP, I don't know what the other one would be, but it's not an EXP listing, then legally you're not supposed to answer questions or show the property until there's a buyer representation agreement or a waiver of some kind. Now, even if your brokerage is the listing brokerage, you would still want the buyer to sign a BNA form, which is a buyer non-agency. I know, right? So you'd be saying to them, well, we represent the seller and I can show you the property and I can answer your questions, but you have to understand I'm doing that as an agent of the seller and we're not acting as an agent for you. Here's a buyer non-agency form, sign it. Or you could use the California Association of Realtors open house and non-agency sign-in sheet, which is exactly the same thing as the buyer non-agency. It's got a little explanation, and you're basically saying, I represent the seller and I can answer your questions, but I'm doing it on behalf of the seller. And at this point, I'm not your agent. If they want you to represent them on other properties, or they want you to be their agent. And the way I would explain it is let's say Nancy is the listing agent and I'm the agent doing the open house. What I would explain to the buyer is Nancy, even though eXp Realty would be representing both the buyer and the seller in this transaction, Nancy would be the assigned agent, the designated agent for the seller, and I would be your designated agent, and I'm going to be on your side. I'm going to help you, and Nancy's going to be on the seller side and help them. Does that sound good? All right, let's do it. Let's sign. Does that make sense? Any questions about that? The law says before the offer. I heard something.
So if you're representing EXP, you're still representing the seller, but if you're sitting in an open house at, like, say, XYZ company, they start asking specific questions about, is there any offer, so on and so on. Does that count as a buyer broker
Situation, yes. So if somebody said to me, so do you have any offers? Are there any disclosures? What can you tell me about the property? What's the elementary school? I would say, well, are you working with an agent yet? Now, if they're going to say yes or no, sometimes they say, well, I don't know, right? We've been talking to so many people, it's all a dream, you know? But if they say, they're going to usually say yes or no. If they say yes, then I would say, well, I'm not allowed to represent you and answer questions about the property if you already have an agent, because that's who's supposed to be doing this for you. Why don't you fire that in? Oh, never mind. But if they say, no, I don't have an agent, then I would say, okay, I would be available to help you. I would help you with this property. I'll help you with other properties. I'll get you all the information, but you're going to need to hire me as your agent. And one of the lines that I've worn out probably, but I would say to people at an open house, I would like to apply for the position of being your real estate agent. How about that? Short meeting, let's do it.
Okay, Michael, this is poor. I'm trying to understand this. So I have a couple questions. So if with the context, in the context that you said, if it's ABC Realtor or broker, and the home is listed with XYZ broker, and I'm holding the open house, then I would need to either use the open house par form or the buyer representation form for that particular property in order to answer questions, or do I have them sign the par form and then turn around and tell them that they have to go back to their agent and the agent will answer all the questions they have regarding the property?
All right. Let me see if I can. First of all, most real estate agents are ignoring this. And they're just answering questions of anybody that walks in the door because they want to be friendly and helpful. The downside of ignoring it is that, according to CAR Legal, they know that testers have been going to open houses to see if real estate agents violate the rules, right? And then they, rat you out if they see you doing it. So if somebody wants to walk around the house, here's a flyer, go ahead, take a walk, see what you think. Right now, that doesn't require a buyer representation agreement. That doesn't require that they sign a special sign-in form. They come back and say, we have a bunch of questions about the property, maybe you can answer some questions. I would say to them that, are you working with an agent yet? And if they say, well, yes, well, your agent is the one that needs to be asking those questions, because obviously, if you've signed a buyer representation agreement with the agent, then I don't represent you. Now, if it's an EXP listing and I'm an EXP agent, I have the option of just answering their questions because it's our listing, right? Ours being, EXPs. If they say, well, no, we don't have an agent yet, I would say, well, look, if you, has anyone ever met with you and showed you how to get the best deal possible when buying a home in a market like we're in today? Have you ever had that kind of a conversation with anybody? In the kind of market we're in right now, it's hard. And then I would be giving them a reason to meet with me or to talk to me about me representing them, and that I would answer all their questions about this property and any other properties they're interested in.
Okay, so that answers the buyer representation form. So at what instance would we have to use that CAR special form?
You would, if you were not doing an open house for an EXP agent.
Okay,
Or
got
doing
it.
an open house for Century 21, God forbid. But let's
Okay,
say you were, then you don't have the legal right to represent the property. But if it's the same broker, everything's cool.
Okay.
All right.
That clarified it. Thank you so much.
All right, good. All right. And by the way, I can see an advantage of all this in that, see, my explanation of how to get a good deal is to tell buyers that if you're looking on Zillow and going to the open houses, you're never going to get a good deal because the good deals are bought before the open house. And I would say to the buyer, have you ever noticed, like, you're planning to go look at some open houses on the weekend and on Friday they disappear? They're no longer being held open. What happened to them? Well, the answer is they were sold during the week. Why were they sold? Because they were a good deal. And if all you're doing is going to open houses and looking on Zillow, you're never going to get the best deal. Now, what that would mean, however, for you to get the best deal is that when something comes on the market on Monday or Tuesday, you get access to it immediately so you can make an offer on it before somebody else does. In order to get that access, you're going to need to have an agent. Now, you can try and talk the listing agent to doing it, but why should they? They're not being paid anything to represent a buyer, right? They're not being paid anything. So why should they? Plus, you've got, you would be far more effective if you had your own agent that was getting you access so you could get to the properties as soon as they came on the market. Doesn't that sound like a good plan? Right? And then you sign them up. For common interest development utility repairs, just threw this in. If there are, have you ever been to a condominium complex and lights weren't working and things like this? If there are utilities in a common area and it goes down, they have 2 weeks in order to do something. What happens to them if they don't? I don't really know. Unlicensed contractor. We're talking about the difference between a contractor or a handy person. Handy persons, handy people. Now, the old limit was $500. And by old limit, I mean the limit that most of us were violating regularly was $500. The $500 has been raised to $1,000. So we'll be violating the rule probably less. But what it's saying is that if you hire a handy person to do the work and it costs $1,000 or more, they have to have a contractor's license. Now, is that $1,000 of work? Is it $1,000 of labor? Is it $1,000 of material? Is it combined? The answer is, well, it's combined. Well, what if the seller goes out and buys the paint and the materials on his or her own and brings it to the project and then just pays for labor? Does the store-bought stuff count? The answer is yes. If the owner already had the paint and the boards and sitting around that they had bought from a previous project, does it count to the $1,000? The answer is no. How would they know? I don't know. But you see where this goes wrong, like how would they find out? How would this be an issue? Why would I really care about this? Let's say the handy person gets hurt on the job. Workers' compensation. They want to file. They want you to pay, right? Then all shall be exposed. So that's that, right? And I think in real estate, hire a lot of handy people. New disclosures. A long time ago, this is one of those, I'm so old. I remember when the purchase agreement was one side of the legal page and there were no disclosures, no required disclosures. It was called buyer beware. Good luck. First required disclosure was agency. That up until a certain time, I don't want to say the date, but up until a certain date, you didn't even have to do that. The second big law was the transfer disclosure statement, which came around-ish the same time. And then the seller property questionnaire, which the CAR wrote, is for all the different things that we're being told we have to disclose, but there isn't a particular form for it. So there's new disclosures. Most of these have been put into the SPQ about water tanks. If you got a disaster drought water tank, which was given to some people, I never got one. You have to disclose that. You have to disclose if there's any local or state bans on gas appliance replacements. I have a rental that's up in the sticks that's going to be coming on the market. Wood burning, I mean, that's it. You have to get a special permit in order to do that. And it also recommends that electrical panels be inspected. That's just part of the advisory. Fair housing law expansions, the Unruh Civil Rights Act, which is a state law that deals with business establishments, has been interpreted to be more than race, color, creed, sex, national origin, ancestry, marital status, but to include other things like it, including lifestyle, which includes hair and, for that matter, tattoos. You're not supposed to tell somebody, I'm not going to rent to you because I don't like your tattoos. All right, it's discrimination. Foreclosure laws, 90-day delay before third parties may solicit homeowners for surplus funds. Active listing submitted 5 days pre-sale, trustee sale by 45 days, another 45 days, property can be sold. All right, so what is sometimes very confusing for investors and real estate agents helping them when they want to buy a distressed sale is that you see the notice of default and then you see the notice of sale, and is there an auction or wasn't there an auction? There was supposed to be an auction. You don't really know unless you physically went there. Then what happens? Who knows? And so what they've created is sort of this buffer where one of the things is that it can't be sold at the big part of this is it can't be sold at a trustee sale for less than 67% of fair market value. So what happens at a trustee sale, right? So the notice of default has been recorded. There's 3 months. The seller, the buyer, the owner of the property can make up any missed payments. The notice of sale, the auction is recorded. It's 3 weeks before they have the auction. Now, what happens at the auction is if nobody bids the amount of the first loan, or whoever is doing the notice of sale, whoever that lender is, if nobody bids the amount of the first loan and the costs of sale, the lender has the right to just take the property. Well, what if none of the bids, I mean, the bids don't cover the amount of but none of the bids are anywhere near the real value of the property? Well, in the past, that was just too bad, right? We didn't get a high enough bid. The lender says it's going to be REO, bank-owned property. We're just going to take it. Now the bid has to be at least 67% of the fair market value. One of the more fun areas are landlord, tenant, and tenant protection. Let's say you have chosen, well, I'm trying to think of a nice way to put this. It's hard to put it nice. Let's say you're in a relationship and the person you're in the relationship becomes abusive and you've given them a key and you don't want them to have a key because they become abusive. The new law says that you can tell the landlord, and the landlord is going to have to change the locks so that the abusing person can't have access. If the landlord doesn't do that, this, by the way, is on the landlord. If the landlord doesn't do that, then the tenant has the right to just go ahead and do it and bill the landlord or subtract it from the rent. What happens if the tenant gives out another key to another person and that goes sour too, and wants the landlord to do it again, the landlord has to do it again. How about a third time? Yeah, the landlord has to do it again. Okay. And can the landlord screen people by asking them, have you ever had the locks changed on a previous rental, or we're tracking lock changes on previous rentals? And the answer is no, you can't do that. Everybody get it? That's one of the big changes involving tenant protection laws. Another has to do with application fees. So what you would need to do to not come in conflict with the application fee rules is to start by having a very specific criteria for who you're going to rent the property to. And you could say, I want a credit score above this, I want so many years of employment, I want a certain amount of income, I want a certain, percentage or less of debt. And if you make that criteria public and you accept the first tenant that qualifies, then you got no problems. If you don't make that criteria public and 10 people apply and you send them through Rent Spree, right, which is the California Association of Realtors system, it runs a credit check, it does this check for them as it's called a rent score, and it does all that, and there's a fee. Now, what this is saying is that, first of all, you can't charge the fee unless you really have a unit available and you've done a screening report. It also says that you have to give them back their money if they don't get the apartment. Well, what if I don't have the money because I had them pay Rent Spree directly, which is what I always do, right? And they don't pay me and I pay Rent Spree, they just pay Rent Spree. You still have to give them back the money, because Rent Spree is going to tell you that they paid $60 or whatever it was with their rental application, and they didn't get it, and you then have to give them their money back. Even though Rent Spree has it, you still have to refund their money. So if you're really specific, this is what we're looking for. First one that applies, and you say you verify all of this. And now if they lied to you, if they say, yeah, don't worry, our credit score is above that and we've got plenty of income, and then that's not true, you're in a different position. But if they meet the requirements that you've put forth, or if you don't have any requirements and you don't select them, you've got to give them their screening feedback. Mandatory rent reporting. Large landlords, if you weigh over a certain, no, that's not right. It's got to be, what is it, 15 or more units or something like that. It applies. I have more details about this coming up. But let's say you've been paying your rent on time for a long time. That doesn't necessarily get reflected on your credit report. So if there's, and I think the number is 15 or more units, if it's a big apartment, it's a complex, the tenant has the right to tell the landlord that I want you to report my rent payments to the credit reporting bureaus. And the landlord is supposed to tell you that you have the right to ask for that so that it can be reflected in your tenant score. Commercial tenant rights, I'm not going to really spend a lot of time on this. You have to translate the lease into the tenant's language. They're basically making it more like a residential in some ways. Probate exemption. Well, what the old rule is that if there was real property in a probate situation, and what was the exact number? It was worth $184,000 or less. I think it was 184. It might have been 182. Then if the real property was worth less than that, it could just be removed from the probate and sold and handled differently. Now, the question is, we're in California, And how many properties do you know that are worth 184,000 or less? You know, so it really didn't come up. Well, the new rule is 750. So if there's a property being used as a primary residence, it can bypass probate if it's valued under 750,000. And that's starting now. Swimming pool and spa safety regulations, they have to verify pool safety features. You see this on home inspections already. They basically want a child-proof gate around the swimming pool, among other things. And home inspectors are now required to check that if there's a pool and put it in their report. Landlord restrictions on fees and notices. Landlords can't charge tenants for notices, right? They can't charge tenants if they write them a paper check. And there's added protections for military tenants regarding security deposits. All right. What is the maximum security deposit that can be charged by a landlord in California right now? Anybody want to give that a shot?
3 times the amount.
How much?
Months.
Zero. Zero.
Zero. So under some circumstances, it could be 2 months. If you're not a corporation and you don't have very many units and that sort of thing, like you're renting out a single family home. Other than some specific exceptions, it's 1 month. And if the tenant is in the active military, you can only charge them 1 month, even if you're in the category that normally could charge 2 months. It's only 1 month. What about a pet deposit? First of all, can I refuse to rent to tenants that have pets?
It depends on how the pet is kept and if it's registered as an emotional support animal or a service animal.
Yes, very good. The legal distinction's a little more finer because if it's a service animal, it's not a pet. So as a generic answer, you could regulate pets, but not if they're called a service animal. And so they're all service animals nowadays. Can you charge an extra deposit over and above the security deposit as a pet deposit?
Yes, I believe so.
The answer is no. The security deposit is all money collected by the landlord in advance other than the first month's rent. It doesn't matter what you call it. You could call it a security deposit. You could call it last month's rent. You could call it a key deposit. You could call it a pet deposit. You could call it a deposit, right? It doesn't matter what you call it. If it's anything other than the first month's rent, it's lumped in as a security deposit and the amount is regulated. Yeah. That was fun. Mobile homes, unlawful detainer. That's when
2992.
I hear voices again. Is it just me? All right. So I have more links to some of this if you want to read. I don't know if you really do, but if you don't pay your park, and if you're in a mobile home park and you're not making your payments on the lease, they now have to evict you just like a standard eviction case, which they didn't before. There's a rule about mortgage fraud protections, and what this has to do is with some of the companies that are saying we have bridge loans. A bridge loan, they used to be called swing loans. It's a loan to bridge from where you live to where you're buying, and they would say this is a short-term loan and all of that, and it'll just be for a couple of months until you're able to get your money and move. But then it turned out that really wasn't the loan they were making. They were making a regular long-term loan, and they've now liened the property, and that's now called specifically mortgage fraud. And mortgage brokers who do this could face felony charges. Rent cap. What is the maximum amount of rent that the increase can be every year in California? Does anybody know? Maximum
8%.
8%.
8.
All right,
That's my answer.
that's your answer.
Isn't it 10?
10%?
10%. Any other answers? Uh-oh. The answer is we got no idea because the amount varies by county. And there's a website, CAR has a link where it tells you if you're in Kern County, for example, it would tell you because it's based upon how much the cost of living has increased in that area. And then there's partly a state cap, but it varies every quarter. It can change. The exact number can change, and it varies by counties. So Santa Clara County versus San Diego County could have totally different ones. Plus many counties, in addition, that's just the state law. In addition to that, there are local laws that also regulate it. You'd have to look it up. Right. I don't know, like I can't say, even though I've got a rental coming up, I can't say because I don't, I'd have to go and do the research because it's based upon the cost of living increase within the county plus 5%, something like that. Maximum being 10. The maximum is 10%. Unless, one of the other things to think about this is, if you rent to a tenant and it hits 1 year, it triggers the rent cap and, more importantly, the just cause eviction. So the just cause eviction, the California law lists 15 circumstances, which although sounds like a lot, most of them are not very practical, of when a landlord could throw the tenant out. Can the landlord just increase the rent to whatever they think it ought to be? No, there's rent cap. The landlord just wants to get rid. No, you can't do that. That's not a just cause. You're selling the property and it would be easier if the tenant wasn't there. No, that's not on the list of what is a just cause eviction. So what would be an exception to you can't throw the tenant out if you are moving in? And they've tightened it. This is coming up where it used to say you are a family member. Well, what would that mean? Well, children, maybe grandparents, yeah, uncles, aunts, cousins, second cousins, third cousins, twice removed, and so they've tightened the list where it's got to be an immediate family member and one of them are moving in. That constitutes just cause, but you have to give 60 days notice. Who gives the 60-day notice? The new owner of the property. Because the current owner of the property isn't going to be moving in, right? So they don't have the right to tell the tenant you have to move out. But the buyer of the property has that right if they're moving in or, a close relative is, but then they have to buy the property with the tenant in it, then give the 60-day notice. Right. By the way, if you're on my team and there's an offer we're writing and it involves a tenant in the property, talk to me. Talk to me. All right. So this is the point about 12 months. Once they've been there for 12 months, this gets locked in. So what many landlords are doing is the first lease is 11 months long, not a year. Why? Because when it hits 12 months, you have a tenant just about for life. Just about. Unless the building has to be renovated, or you're personally moving in, or they don't pay rent, or otherwise violate the terms of the lease. But if none of those things happen, you're stuck with them forever. If it's 11 months, then you can evict them, which means not continue for any reason or no reason. But at 12 months, gotta have a good reason. Insurance market, this is still in flux. There were a bunch of insurance companies that said, because there were fires and things like that, well, we don't want to pay people, we want to raise rates, we want to do things, and they've been permitted to raise rates, but they're being, regulated a little bit about coverage options. The FAIR Plan, which is the state plan, doesn't have very much money, and if everybody started using it, they would run out of money. Corporate transfer, I'm not going to do that one. Rent cap law refresher. It applies to residential properties with 2 units, 15 plus years old, where the tenants have lived 12 plus months. 2 units. So if I'm renting out a single family property, I can do what I want. I'm not under the state rent cap law. I might be under a local one, but not the state one. Okay. Okay. What if I have a duplex? Well, if you live in half of the duplex and rent out half of the duplex, then you're exempt from the law. If you rent out both units in the duplex, you're under the rent cap law. And I gave an example. San Diego County was 8.6% for the 24-25 period that they were measuring it. But as I said, it varies by county. It does not apply to single family homes unless owned by corporations or REITs. A REIT, of course, is a real estate investment trust. New buildings under 15 years old or owner-occupied duplexes, right? Those are the exceptions to the rent cap. Security deposit, photo documentation. If you're a landlord, you're going to become a photographer. Yeah. Because starting, April, landlords have to provide move-out photos to justify deductions exceeding $125. So what they want you to do is to take pictures, which, by the way, was always a good idea. But the tenant, there's a move-in form that CAR has. You would take pictures showing everything, right? So you could see that when they moved in, there were no scratches on the range and no marks. You just take pictures. And then when they move out, you take more pictures. And if there's a difference, now you have a claim on the security deposit. It is no longer legal for landlords to put in the lease or otherwise require that the tenants pay for professional cleaning services when they move out. The reason is that, let's say they're, clean people, and when they move out, it doesn't need professional cleaning services. Can you just charge them again anyhow? No. So for those of you that want a refresher, what are the 3 things you can use the security deposit for? Number 1 is covering unpaid rent. Number 2 is to repair damage, not normal wear and tear. And number 3, for the property to be clean. And although this is not a well-litigated area, although there was one appellate case that made its way up, to where we act, because if it's not an appellate case, we don't have a copy of the record, right? It's not, and what that court said, that clean meant broom clean. That's what they said, broom clean. It does not mean spotless, right? Broom clean, free of personal property, debris, and things like that. So landlords would just say, hey, we're going to charge you for professional cleaning. You're going to have to agree to pay for it. You're going to either have to have it done or pay us to have it done. You can't do that anymore. The positive rent reporting notification, I already mentioned, if you have 15 or more units or own multiple properties, must notify tenants of their right to have on-time rent reported to the credit bureaus. And they can opt in or out, and you can charge them as much as $10. Why would they opt out? Well, because they're not planning to pay the rent on time, right? And so they say, I want to opt out. I don't want you reporting that. Tenant lock changes. I think I may have duplicated myself a little bit here, but I was trying to be as thorough as possible. This has to do with victims of abuse, harassment, or threats, 24 hours. The landlord can't say, prove it, I want to see a police report, they just have to do it. Landlord doesn't do it, tenant can do it, and you can't evict somebody just because. And I did the application fees, I may have done this a little doubly, I guess. Any questions about this? I mean, any thoughts, questions?
We are absorbing it.
Let me know
Thank you.
when you've got everything.
Great information. All the good stuff.
The big one, of course, has to do with biorepresentation, right? And if you're not doing rentals, a lot of this doesn't really matter as much. If you're on my team, which some of you are, and you've got the tenants in the property are the ones that sometimes cause the most difficulty, right? So talk to me about those transactions.
Mike, I got a question about back on open houses. You mentioned the open house and non-agency sign-in sheet. Is that a car form or is that an EXP form?
It's a car form.
Okay. Thank you.
EXP, as do most brokers, have sign-in sheets, but the California Association of Realtors has put in, special legal language, which essentially says it's the buyer non-agency. It's word for word the same as the BNA form, the buyer non-agency form, which it says that just because we're giving you some information, we're not your agent. And you realize that, because what you don't want is for the buyer to come back and say, well, I thought Khalid was my agent. He was so friendly and was answering all my questions. Now I find out that he's not representing me at all. Oh my God. No one told me. Is that it? Well,
I have a question.
okay.
If you have tenants and if you have tenants in property you're selling, is it possible to ask them to leave sooner than 60 days?
Right. Well, what we normally do is there's a form called TOPA, and TOPA stands for the Tenant Occupied Property Addendum. Now, the tricky thing about this is, let's say a nephew is living in the property with the owner. The nephew is not paying rent. The nephew has not signed a lease. Is the nephew a tenant occupier? This was
I would say no.
You'd say no. Any other guesses? There's only yes or no, really.
I say yes.
The answer is yes.
Oh.
So the word tenant does not mean renter. This is a revelation for some people. The word tenant does not mean renter. Ever heard of a joint tenant? A tenant in common? Those aren't renters.
Yeah.
So it obviously doesn't mean renter. It comes from the Latin word tenare, which means to hold. Like tenacious people don't let go. Tenured teachers can't be fired. So it has to do with somebody that's got a hold of the property who isn't the owner of it. Is that nephew eligible for just cause eviction rules, even though they haven't ever paid any rent, nor have they signed a lease? And the answer is yes. They're covered by just cause eviction. So that's why on the new revised SPQ, there's a question about, does anybody else live in the property, paying rent or not? So what we would do in TOPA, so TOPA would apply whether they're paying rent or not, simply if there's somebody other than the owners living there. All right, not children, right? So what the first box is in TOPA near the top, which is we want the property to be vacant at the time escrow closes. Because otherwise, unless your buyer wants to buy property with a renter in it, but you understand this is a rent-controlled renter, they may not want to buy it, but they want to move in. So what the landlord owner has to do is go to the tenant and say, look, I'm selling the property. The buyer is most likely to be moving in, not wanted as a rental. You're going to have to leave. You're going to have to. And by the way, I'm sure most of you already know this, but under the just cause eviction rule, if you're making the tenant move out because you're moving in, you have to give the tenant a relocation allowance, which is equivalent to 1 month's rent. This might be changed by local jurisdictions. So if you say to the tenant, usually this is called cash for keys, you say to the tenant, what's it going to take to get you out of here early? I'll pay 2 months. Your security deposit. I'll pay you 2 months rent. You sometimes have to offer them more than what they're going to get anyhow. Because it's a whole lot easier to sell the property, and you're going to get a lot more money if it's not tenant occupied. Right, because they're not going to let you show it when you want to. They're not going to keep it clean. They're going to keep telling you it's not convenient for you to do that open house, and it's going to cost a lot of money. So you want to get the tenant out. Now, if you look at the TOPA form, after the property is going to be vacant by close of escrow, none of the other choices look very good. Right, because basically the buyer's taking the property subject to the rights of the existing tenant, which most of them do not want to do.
So, Mike, if you have an adult tenant in the property that has not signed a rental agreement, and you have to, the regular tenants who signed the paperwork are notified. Well, everybody's notified that they have to leave the property. What if the one that hasn't signed the lease doesn't want to leave?
Oh, you have to evict them if you have a just cause. So you don't have a right to just tell people they have to leave just because you want them to, whether they've signed the lease or not. The laws on this do not require a written lease. It just requires tenancy. Right?
And you're saying something to the effect of that 11 months versus 12 months?
Right.
So if the lease is for 11 months versus 12 months and renewed at 11 months?
Right. What I'm saying is that it's at 12 months that the just cause eviction protections kick in. They don't kick in 11 months. So if you sign a lease with a tenant for 1 year, you better hope you're going to like them. Because
okay, so if they signed it for 11 months, can it be renewed for another 11 months, or does it have to be renewed for 12?
It doesn't really matter, because if you give them 1 more month, even
it's considered 12 months.
Now 12 months.
Okay.
Right. But at least you have a chance to test drive the tenant for 11 months to decide whether or not you want them to be your tenant for life.
Got it.
Right. And if you wait, most of us just do 12-month leases because, the landlord says so, and I always say, I just want you to understand what this means. That you're not going to be able to evict them for any reason you want to, unless it's less than 12 months. All right. Okay. Well, I hope you all enjoyed that as much as I did.
Thank you so much, Michael.
I hope you enjoyed it more than I did. All right. Well, thank you very much.
Thank you.
Thank you.
Take care.
Take care, everybody. Have a good day.
Thank you, Michael.
Good afternoon.
Bye.
Bye-bye.